there's just been so much to put on, and she's been very gracious. And people who did testimony late, we keep trying to put it on more and more. And so we need to be patient. Some of the bills that we have to hear today are not on the S drive yet. She's going to put them on right now. It's all on now, so it's all good. So I'm sorry for that, but I will tell you, we're going to work a bill first. And for a couple of purposes. One, might give people a little bit of a chance to look at the S drive if you want to go over some things. And then the other reason is Representative Curtis is on the Appropriations Committee, and we want her to be able to vote. She has to vote, of course. She has to be in the room. So if we had 4 hearings and then work the bill, she would probably have to leave for her 5:15 or 5 o'clock appropriations. So we're going to go ahead and work the bill first of 2134. And that may give everybody a chance to kind of catch your breath before we start our hearings on the 4 bills that were in here today. So 2134, by the way, it's the only bill that we're going to work today, because another personality trait that the committee assistant and I both have is long suffering, I think, because I want people to come together. And so there's several bills that we have that the parties are very close to come together, but we don't have all those amendments done yet. And so I'm hopeful that we'll be able to work those bills with amendments that everyone agrees on. We'll see if that can happen or not, but we're not rushing it for today because things were not quite ready. So we're just going to hear the one bill today, House Bill 2134. So I'll ask, sorry. Yep, it's 73. We're not ready on 2134. I'm sorry, everybody. We're doing 2173, which is the Offender Registration Act. So, Jason, if you could give us a reminder of what that bill's about.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. As you mentioned, 2173 is about the other KORA, the Kansas Offender Registration Act. This is the one that gives the relief from registration for certain offenders who had their registration period changed by the 2011 amendments to the Act.
Okay, committee, let's discuss this bill, see if anyone has any amendments. Representative Barth.
Thank you, Madam Chair. I do have an amendment for HB 2173. I'll wait till everyone has it in their hands.
Okay, Representative, would you like to explain your amendment as you're passing it out?
I can. I think we discussed this a couple days ago about what my intent was. This amendment has been revised to be very specific, to address a very specific person that would change it. So most of this is just reorganizing, redesigning it, but there on line 31, where it adds a sex offender who's required to register for an offense in which the victim was less than 18 years of age, may only file for petition for relief from registration requirements if the victim was at least 14. So this, what it's doing is the term's called a Romeo and Juliet romance. So this is the high school love story where maybe the parents didn't agree, and so this person was put on trial. It excludes them. They actually will, or it means that they could still petition the judge for this. What it is saying, though, is that for someone, a victim that was under 14, so an actual child, an adult is doing a sex offense with a child, that person would not be able to petition.
Okay, thank you. Committee, what questions do you have for the maker of the amendment? Representative Schreiber.
Thank you, Madam Chair. Maybe it's the wording that's kind of throwing me a little bit. So the victim has to be less than 18, but at least 14? Is that the way I'm reading it right?
So on there, thank you for the question. Madam Chair, I might. So they're less than 18 years of age. Okay, if the victim was less than 18,
Right.
but older than 14,
Okay, that's,
then they can still petition. That's the Romeo and Juliet folks. But then you say, if they're under 14, then that offender would be excluded from being able to petition if the adult was truly with a child under the age of 14. And I tried to take in the different comments I heard with everybody to find something that would really work for a majority of the committee.
okay, I think I've got it. It just seemed like the wording was a little strange. So, okay, thank you.
Okay, other questions for the amendment? Sorry, Representative Osman.
Thank you, Madam Chairwoman. I've got one question, then I'll save comments until after the discussion. So if there was a perpetrator that was 15 years of age and the victim was 13, and that person was sentenced, that person would remain upon the sexual offenders list for life.
Those are both children under the age of 18.
But it says yes, the victim is still under 14.
But you're also saying the person doing this is also under the age of 18,
Yes,
so
that's
they're a
correct.
child. They wouldn't be an adult. So they wouldn't be on that registry. And I will also defer to the revisor on that question too.
What is the youngest age that that somebody can be registered on this list?
Madam Chair, so any juvenile offender can be on the registry. So, I mean, I suppose the youngest age would be 10. That's when you can be charged as a juvenile offender. But I don't know that any 10-year-olds are on the registry.
Okay,
Representative Osman, did you have
thank you.
further questions?
So as I understand it then, so a 15-year-old or a 13-year-old or a 10-year-old, hypothetically, could be on this list. And with this proposed amendment, they would be in the list for life.
Are you asking the revisor or?
Yes, sorry.
Madam Chair, I'm doing my best to stay out of this. All right, so what I wrote, and I apologize if I didn't get there again, I'm trying really hard to get to exactly what we want. I incorporated child victim, which means a victim under 18, and I incorporated an exception for the Romeo and Juliet situation, which is the language that's in the current law about 14 years of age for the victim and not more than 4 years older than the victim for the offender. If you want it to just be victim under 14, we can do that. If you want it to be person over 18, victim under some age, we can do that. There are so many ways I can do it, but this one is victim under 18, so child victim. But if you happen to be within the age range and the victim was at least 14, you would still be able to petition if you were also caught up in the 2011 changes. So we're talking about a subgroup of a subgroup of a subgroup, which is why it looks the way it does, because we're talking about an exception to an exception to an exception.
Okay, thank you very much. I'm going to withhold any other questions as I
Okay.
hear discussion.
Any other questions? Representative Bohai and then Carmichael.
Sorry, thank you, Madam Chair. I'm just trying to remember back to the testimony that we had at our hearing, and I felt like one of the examples given was there was a teen offender that then got there was a teen offender, somehow he eventually got put on the adult list. I'm assuming it was him, and was not able to come off because of the retro action. I felt like he was a teen, or the person was a teen when the offense occurred, but the way that this law went into effect. So I would just, if we can get clarification also of Osmond's, or excuse me, ranking member's question, would just like to make sure we're getting it right.
Okay, so, we didn't ask them specifically what was your crime, so we don't know exactly what they were charged with, the folks that testified. There was someone that mentioned he was a teenager, but I don't know if that was 18 or 17, or I'm not sure. Maybe someone else knows more about it. I do want to affirm one thing. Juveniles can be put on the the sexual offender registration list. So that's a fact. So there are those that probably were juveniles that were put on the offender registration list and had a certain period of time that they had to register, and they could have been caught up into the retroactivity. And so Representative Carmichael and then Martinez.
Thank you, Madam Chair. 2 questions for the reviser, if I might. First, now I understand, Mr. Thompson, I'm sorry. If I had your wisdom, knowledge, and experience, I would not inquire. My recollection, though, is the Romeo and Juliet, so-called Romeo and Juliet law encompasses people who are older than 18, but within 4 years of the juvenile victim's age. Now, I may be wrong on that, but I thought it covered, for example, the 18-year-old and the 16-year-old girlfriend. Help me with because this amendment does not appear to be that.
So, Madam Chair, correct on part 1. 14 years of age is the minimum for the victim. Within 4 years older than the victim is the offender. And second part, that is what this language is at the second clause. It's if the victim was at least 14 and the offender was not more than 4 years older. So if the victim was 17, add 4. That's the range.
With all due respect, Mr. Thompson, I don't read it that way at all, but we'll discuss that, I suppose. My second question is, with or without the amendment, is there anyone who is presently not required to register who would be required to register under this bill, either as amended or as it stands? In other words, are we broadening, to your knowledge, any registration requirement to catch someone within this net who is not already caught, if you will?
Madam Chair, Representative, that's an easier one. No, this only changes the ability to get a petition for relief. It does not change any registration period or require anyone to register. It's only allowing folks to petition to get off the registry.
Madam Chair, that's an easier question for the reviser, but makes my decision here more difficult. Thank you.
Representative Martinez.
Thank you, Madam Chair. It may have been clarified just now, but just for clarification, this is just a petition for relief to get off the registry. Am I right? A judge, they would go in front of a judge and the judge would make that determination based on the individual cases. Okay, I just want to be clear on that because there's so many different scenarios where one would be required to register, be charged with a sex offense. Okay, thank you.
Representative Barrett.
Thank you, Madam Chair. And I also wanted to clarify, so previously during our committee hearing, I had asked what crimes would all be involved. And I had a list that I thought was complete. And after talking to legislative research with Representative Vaughn, as well as a few others, there's actually quite a few more crimes that were at the 10-year registry at that time. And Representative Vaughn, feel free to step in if I'm incorrect in any of these, but they do involve kidnapping, aggravated kidnapping, criminal restraint. Then you have the ones that we already kind of mentioned, like adultery, criminal sodomy. But then we go to, there's also aggravated crimes. We have rape, aggravated indecent labor with a child, criminal sodomy, aggravated criminal sodomy, sexual exploitation of a child, aggravated sexual battery. So there's quite a few more crimes on this list that could, in my understanding, could petition relief if this were passed. So that kind of changes what I had originally thought.
And do your comments, how do they relate to the amendment?
So with the amendment, I think some of the aggravated crimes, at least, that would help kick some of those off. So I would be in support of the amendment.
Okay, thank you. Representative Schreiber.
So my question is related to one of the conferees, the first conferee, I think it was a couple that was here from Garden City. If it was an internet solicitation and the person on the other end of the communication said she was 13, but was not an actual 13-year-old, how would that work? And maybe Brad would, or Representative Barrett can help me with that too, but is there some distinction here when we talk about victims in the amendment and that situation?
I hate to bring the revisor back into it, but from my understanding, doing the solicitation cases that we've done, there's really no difference when it turns out who was doing the communication. It was what age was given to the offender. Like, hey, I'm 13, by the way, during the chats. It doesn't matter if it's, and then again, I can be checked on that. That's just my understanding.
I'm wondering, maybe, because if they say they're 17, but they're really 13, then the age, you think it just matters what?
I was just talking about the law enforcement version. I believe it's a status offense, so it doesn't matter what age they put off. It's
Okay.
what age they actually are.
And do you think this has to do with the amendment? Representative Carmichael, if you do, go ahead.
Number one, I have something very specific about the amendment, but I think what we're confusing here is that it's typically a strict liability offense. It doesn't matter how old he or she says they are, but when as far as the victim, but when law enforcement attempts to deal with these people, the person can be 21, 25, whatever, portraying themselves as 13, because that's the way these stings work. Law enforcement doesn't go out and hire 14-year-olds to set people up. Going now, though, to my question, I apologize, Mr. Thompson. His interpretation was correct a moment ago. The Romeo and Juliet law and this amendment applies to adults and juveniles alike, so long as they're within 4 years of the victim's age. I think that's what Mr. Thompson told me, and I disagreed with. I was wrong once again.
Okay, any other? Oh, I'm so sorry. I can't believe that was turned on. So sorry. Okay. Whoa. Woke everybody up at least. Okay. Are there any other comments or questions? Representative Vaughn.
Thank you, Madam Chair. Just a comment for the committee's consideration. So the one individual we did hear from who came in person, he, in his testimony, he was under 18 when the crime occurred, but I don't think and again, this was an attempt and potential solicitation. I think the victim was more than 4 years younger than him, so he would not qualify for relief under this amendment. So I don't know how people feel about that, but because he was the one specific example we had, I do think that was important to bring to the committee's attention.
Thank you. Okay, Representative Osmond.
Thank you, Madam Chair. So now that I've asked my question, just a general comment on the proposed amendment. I think it is very easy for when we hear of a crime for us to go, that is bad, that is wrong on an individual basis. As you can see from this discussion here today and multiple attempts at revision of this, it is much more difficult to take that in the conglomerate and go, all of this is bad and all of this should fit one way. And that is what happened, I think, in 2011 when the legislature, the reason that we're here today is because in 2011, the legislature went, all of this is bad. And now we're trying to correct that issue. And we're the legislature, we're not judges. And I think the whole point of this bill is that to allow judges to judge, not necessarily to give people the freedom, just to allow judges to judge. And the more we restrict that, the more we're playing with things outside of our understanding and our control. And so I support the underlying bill. I don't know that I support the amendment because I think that, again, we should just allow judges to make that judgment. Thank you.
Okay, any other questions or comments? Representative Carmichael.
On the amendment, I disagree with my learned colleague. I think that this is probably good. And I think this gives judges more opportunity to judge. And the second thing that I think is this is not just for the benefit of one person at all. I can think of a friend of mine's son who would fall directly within this, and my guess is there's a lot of other people that were in that same circumstance. They were of age, their girlfriend, boyfriend was not, and we need to give some of those folks relief if they fit within the so-called Romeo and Juliet law. I support the amendment, and I'm going to support the bill. It's not as broad as I might like, but I'll certainly support what we have.
Representative Barrett.
Just to clarify, we're only talking about those offenders pre-2011, right? 2011 and prior that were charged with this offense. So everyone is still lifetime at the 2012 and after, all those individuals will still fall under current statute and current registration requirements. This is just 2011 and prior. Am I correct in that, Madam Chair?
Yes. But, I have a clarification or question about the amendment. The amendment is giving less people the opportunity to apply for relief. Is that your intention?
It's giving, I'm sorry, what, less?
Less people the ability to apply for relief.
Meaning it's
you're-
going to only affect a minor amount of people, most likely a lesser amount than, the scope is scaled down, so it's only this.
So if anyone was caught in the retroactivity, the bill says that they can apply to exit the offender registration. You're saying that now not everybody caught in that retroactivity can apply because there's going to be these. So if I understand, you're limiting by this amendment who can apply for relief from the offender registration list.
That is correct, Madam Chair. It's just that small group of folks that are truly sex offenders of children. That is the only population that this really applies to. Am I saying something wrong? Or?
That was fine. I'm afraid that, okay. Okay, Representative Lewis.
Right, so that's what I understand too, is that the proposed amendment would limit or make fewer the number of people who would qualify, who were caught up in the retroactivity and would qualify. Look, I the first two, want rights for victims in this arena, but I'm uncomfortable limiting it because of the retroactivity. I think there is something to be said for the principle, which was the argument from our proponents that even though the courts have determined this is a civil penalty, it really effectively is a criminal penalty. And so I'm uncomfortable. I'm comfortable with the bill for that reason because it eliminates that retroactivity. And I guess I'd also say that I think that the fellow from my district would not then qualify to apply for relief from registration. So I think I'm going to oppose the amendment. And then the other thing I would say is, sitting here today, I'm still a little bit confused exactly who would be eliminated from the retroactivity. So with some regret.
By the amendment, you were.
Yeah, I'm still confused as to who exactly is going to not have the benefit of the registration relief. So with great hesitation, I'm going to vote no on the amendment for those reasons.
Thank you. Representative Carmichael.
Thank you. I apologize to everyone. I think you may have heard me, not in front of the microphone, say I was wrong. I've been persuaded by the chair and the distinguished scholar from Finney County that I was wrong, and so I'll be a no on the amendment. My thanks to those who corrected my error.
Representative, would you like to move your amendment? I don't think you got
Yes,
a
thank you. I close and move my amendment.
And we need a second. We need a second on the amendment. Representative Barrett seconds. Okay, any other discussion on the amendment? Okay, we have the Barth amendment on House Bill 2173. All those in favor say aye. Opposed, no.
No.
I think it's clear that the noes have it. And with that, the amendment fails. We are back on the bill. House Bill 2173. What discussion do we have on that one? Any other amendments or discussion? Representative Williams.
Thank you, Madam Chair. I move that we pass out House Bill 2173 favorably for passage.
Thank you. We have a second by Representative Osman. Discussion on the bill. Representative Barrett.
I'll just say the lifetime registration in pre-2012 still was lifetime for those offenses, for most part, under 14. So I'll still support this bill. Thank you.
Thank you. Any other comments on discussion? Okay, Representative, would you like to close?
I close.
Okay, committee, you have heard the motion to pass House Bill 2173 favorably for passage. All those in favor say aye. Opposed, no. Okay, House Bill 2173 is passed. And recording, yes for Representative Carmichael.
Thank you.
Anyone else? Okay, thank you. Okay, committee, thank you for that. Thank you, audience, for letting us go ahead and get that piece of business done. Yes. Yes, for sure. I'm sorry, I didn't see it. Representative Martinez had a yes vote. Okay, we will go ahead and open the hearing on House Bill 2323. Jason, if we could have a bill brief.
All right, thank you, Madam Chair. As you mentioned, Jason Thompson, Revisor's Office. House Bill 2323 is the bill establishing procedures for a civil action instituted by the Commissioner of Insurance regarding fraudulent insurance acts. It also has a provision about expunged criminal records and a provision about automobile assigned claims plans being added to the Fraudulent Insurance Act statute. I'll try to keep it quick because I know you've got an expert here to testify about how this is actually going to work. Section 1 is the new section that provides the Commissioner of Insurance may bring a special kind of civil action for a fraudulent insurance act. That term is defined in KSA 40-2, 118, which is in the bill as Section 3. So if you want to know what that means, you can look in Section 3 for the definition of what those acts are. The action could be brought in Shawnee County or in the district court of any county where the alleged acts occurred. There's a preponderance of evidence standard, possibility of civil penalties, et cetera. That's all laid out there in Section 1. Section 2 then amends the expungement statute over in KSA 21-6614. As most of you know, under current law, once you have an expungement, you're still required to disclose an expunged offense to certain folks in an application or when asked about it. The bill adds you will be required to disclose in an application for licensure as an insurance producer or public adjuster any arrest, conviction, or diversion for fraudulent insurance acts. So if you have those in your background, even if they're expunged, they will be disclosed and the record keepers will be able to provide that information to the insurance commissioner. Section 3 then amends 40-2, 118, the statute I mentioned earlier, defining fraudulent insurance acts. And the definition, or the main amendment there is just to add references to automobile assigned claims plans in that section. And then the same in Section 4, KSA 40-2, 119, adding a reference to automobile assigned claims plan. And I will answer any questions and stand aside.
Okay, thank you. Committee, what questions you have for the revisor? Okay, none right now. Thank you, Jason. We appreciate it. Okay, we will go ahead and have the proponent, Steve Carrere. Help me how to say it.
Plans, it's CARS, just like CAR.
Cars, okay.
Yep.
Steve Cars from the Kansas Department of Insurance. Welcome to committee.
Thank you, Madam Chair and committee members. My name is Steve Carr, and I'm General Counsel for the Kansas Department of Insurance. A little bit of background for me, which is somewhat relevant to this bill. Prior to coming to the Department of Insurance, I was a prosecutor for roughly 23 and a half years. And part of that was spent with the Kansas Attorney General's Office from 2008 through 2022. And 5 of those years, from 17 through 22, I was the head of the Fraud and Abuse Litigation Division and prosecuted insurance fraud cases for the Attorney General's Office. So many of the cases that we're going to talk about, I was on the prosecution side, and now I'm with the Department of Insurance where we investigate those cases. House Bill 2323 really is about expanding our abilities to fight insurance fraud. As I pointed out, it's a huge cost nationally, but it's also a cost to Kansans. And one of the things that insurance fraud, first of all, can vary widely in the degrees. I gave examples in the bill, but or in my written testimony, I would give one more example today that I think is relevant. For instance, cell phones. There is insurance that will cover cell phones if it is lost or stolen. And one fraud that happens a lot is an individual will report that their phone was in fact stolen when it was not. And they continue to use that phone. They collect the $1,000 or $800, whatever their phone cost from the insurance company, but they continue to use their original phone. Obviously, that's fraud. Their phone was never stolen or lost. I give that example because the reality is with, frankly, all fraud, but probably crimes in general, the ability for crimes to be committed exceeds our ability to investigate and prosecute them. And that is certainly the case in insurance fraud. We get complaints ranging, in 2022, we had about 949 reports of insurance fraud, which are reported from the companies to our office in Kansas, and that's related to Kansas insurance. Roughly 975 in 2023, and a little over 1,200, or right at 1,225 in 24. So we are increasing in the reports of insurance fraud. Annually, we transfer about 20 to 25 cases of felonies over to the Kansas Attorney General's Office to be prosecuted criminally. And the reality is I have been on both sides, right? I've been on the side of the Attorney General's Office. There is a limit as to how many cases they can file and prosecute in criminal court. And obviously there is also a capacity or resource issue on our end at the Department of Insurance on how many cases we can investigate. And so this bill really adds capacity in a couple of ways. The main thing is it allows us now to pursue civil action instead of just criminal action. I want to make clear, even if under this bill, civil action was pursued, it would not mean that they couldn't also be criminally prosecuted. But the idea would be that in most instances, they would simply be civilly pursued. And that does a couple of things. One, the burden of proof is less, which can affect the amount of evidence that has to be gathered, but it can also just affect the process. There's no preliminary hearing. There is just certain things that lower the amount of resources that are necessary to prosecute these. And so this would be basically one more tool in the toolkit to fight fraud. This would allow us to levy civil penalties against individuals and would give us more discretion or a wider ban of cases that we could go after. Those cell phone cases would be a prime example. Those might be very appropriate for a civil action because of the amount being less than what generally would be, or in criminal cases would be a misdemeanor. Those resources could be spent going after civilly rather than pursuing it criminally. And so this really would help, I think. It would certainly increase the number of cases of fraud that we are addressing, and it would also make sure that we can hold them accountable. And I'll stand for questions of anybody. This has two other elements to the bill, but I think the reviser has explained those.
Okay, thank you. I think we'll go ahead and have the other proponent testimony and then ask questions after that, if that's okay with you.
Thank you, Madam.
Craig Seepich from the National Insurance Crime Bureau. I have as a proponent in person. Is he on WebEx, Cole? Craig Seepich. It might be written only. Okay. So I think the other two, we have two proponents written only. So does anyone have any questions for Mr. Carr? Representative Carmichael.
Thank you, Madam Chair. I think I understand where you're going. I think I'm with you. I spent a long time early in my career representing insurance companies who either wanted a declaration they didn't know on the policy or were sued because they didn't pay, and it was fraud claims. Okay. But I presume that this extends to fraud that is much greater than a $1,000 cell phone. I assume when the mortgage papers and the insurance policy get rubbing up together and somehow there's spontaneous combustion and the house burns down, you could also proceed against a $300,000 loss or a $500,000 loss as well.
You could.
And still, even after that, they could be prosecuted as well. Is that correct?
That is correct. This is in addition, not to the exclusion of criminal prosecution.
Thank you.
Any other questions, committee? Representative Curtis.
Thank you, Madam Chair. So you say this will probably likely increase the cases that you will be handling.
That's right.
Capacity in the insurance department to do that?
Yes, and one thing is in our fiscal note, we would add one FTE, so add at least one additional law enforcement officer.
And that would be, sorry, Madam Chair. And that would be in the insurance department?
That is correct, the Department of Insurance, yes.
Okay, a little bit of a facetious question, but is there anything in the world left that does not have an insurance product available? You do not have to answer that.
Thank you.
Okay, committee, any other questions? Okay.
The $100,000 civil penalty or $10,000, who gets the money if you're successful in your civil action?
Right, that would, under the bill, that would go to the Department of Insurance Service Regulation Fund.
That's a problem. I'll address it when we discuss the bill.
Any other questions, committee? Representative Vaughn.
Madam Chair, thank you. I was just wondering, are you aware of other states imposing similar civil penalties? Is this an effective deterrent, or is this something that just kind of, that you think would help with the issue?
Sure. I'm not necessarily aware of any other states that do civil. What I will say is we do civil actions on the security side. We have the ability to do civil actions on the security side. And that is a useful tool in that area as well. I would expect that there are states that go civilly after fraud, but I just don't have any specific examples for you.
Okay, thank you. I don't see any more questions. So, or did I miss somebody? No. Okay, thank you so much for being here with us. Any other opponent or neutral testimony on House Bill 2323? Anybody? Okay, we will close this hearing. Committee, make sure you look at the other two written only proponents, please. Okay, closing the hearing on House Bill 2323. Thank you for coming. We'll go ahead and open the hearing on House Bill 2359, and we will hear from Jason Thompson, our revisor, on a bill brief on that one.
Thank you again, Madam Chair. As you said, Jason Thompson, Revisor's Office. I kept this one pretty short because you already had an informational hearing, and I know you've got a lot more that you could hear about it. So just hitting the high points here. The bill enacts the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act and the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. The bill also repeals the chunk of statutes in KSA 59-2701 through 2708. Those concern estates of absentees. And it also repeals KSA 59-3051 at SEC, which is the entire Kansas Act for obtaining a guardian or conservator or both. That's in current law. So that's why the title and repealer are so long. It's replacing those acts and statutes with these new uniform acts. I kind of gave you a glorified table of contents in the bill brief. Maybe it'll be useful in the future. You know, the first 23 sections are the Uniform Act about jurisdiction. I highlight a couple of pieces about the applicability of that act. It applies to guardianships and protective proceedings begun after January 1st of 2026, which is the effective date of the act. But it also, certain sections can apply to proceedings begun before that date, regardless of whether guardianship or protective order has been issued. So that seemed worth noting. Then the second chunk of the bill, sections 24 through 135, that is the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. It's broken down kind of into articles in the Uniform Act, which we don't exactly do in our version, but I kind of broke them down for you. There's a section about guardianship of a minor, section about guardianship of an adult, one about conservatorship, and one about other protective arrangements. And I kind of laid those out, the range of those statutes in the bill. And then the applicability of that act is in section 134. It applies to proceedings begun after January 1st of 2026, except a guardianship, conservatorship, or protective arrangement instead of guardianship in existence on January 1st, it can apply to that unless the court finds that application would substantially interfere with the effective conduct of that proceeding or prejudice the rights of a party, et cetera. So there is a prospective application, but also potentially a retroactive application, but with some exceptions. So I wanted to highlight that for you. And the last thing I'll say, this is entirely technical and I don't think anybody else will talk about it. Sections 136 through 166, those are amending all the statutes that reference all of the repealed statutes, right? So anytime we repeal 5930-51, anywhere that's referenced, we have to go in, change that statute to reference the new statute. To do that, we have to print the whole section because that's what the Constitution requires. So you get the large bill you have, the final 30 sections are just amending cross-references. And that's all those amendatory sections are doing. As I mentioned, it would take effect on January 1st of 2026, so it's a bit delayed, and I'll be happy to answer any questions if I can.
Okay, thank you, committee. Do you have any questions for the revisor? Okay, thank you, Jason. I will now call the proponents. There's quite a few opponents, so I'm just going to ask you to somewhat limit your testimony. I mean, just know we've got a lot going on. I'm not going to give you a number or anything, but I will call up Rachel Perner. So happy to have you. Thank you for coming up from Wichita, and welcome to the House Judiciary Committee.
Well, thank you. Thank you, Madam Chair. Thank you to all of you for your public service. I really do appreciate it. I have spent close to 5 years now working on this committee, And it has been an interesting journey as we've gone. Initially, there was great hesitation with modifying any of our existing acts. And as we, as a committee, worked through it, the more we liked what the uniform law had to offer. I will say that 23 years ago, when the legislature passed the legislation that we have, we were way ahead of our time. Yes, bless you. We were way ahead of our time as a state. And even with the law that we have on the books today, when we compare to some other states, not to name any, but California, Illinois, we're still light years ahead of those. But as time has gone by and as we've learned more about the aging process and more about, the disability communities, there are some pretty fundamental things that we're missing in our existing act that we believe that we pick up in UGOPA, as ugly as that an acronym is. And by way of introduction of myself, I know a few of you, but I'm an attorney in private practice. My firm is about 25 members. I've handled, I haven't counted them precisely, but over 1,000 of these cases of all different stripes, whether it's, minors that have a legal impairment, which means that there's nothing wrong with them other than they're underage, or whether it is a minor with an impairment, whether it is an adult with an impairment. And before we were impaired under our previous law, we were all disabled. And so now we're going to, hopefully be subject to guardianships as opposed to impaired persons. I've served on the American Bar Association Commission on Law and Aging for several years now, and this has certainly been in their cross sights. Person-centered care and really focusing on what an individual needs as opposed to just shoving people into boxes that maybe don't operate at the same level that, another one will operate with, is not really what we want to do, I think, as a society. I think it's not a good thing. I think it's not a service to the people. And under our existing law, it's an all or nothing proposition. So even though our existing law has embedded in it that we want to make a person who is subject to a guardianship, we want to put them in a position to have input into the decisions, they're still going to be branded with a guardianship or a conservatorship in a very public way. So, what that means under the existing law is that you might have the little old person that is operating fine on their own. They're driving to the grocery store, they're cooking their meals, but they're unable to perform certain tasks, or certain complex issues might come. So they are diagnosed with cancer and they have to sort through, gosh, is it chemotherapy, radiation? Is it going to be, a combination of those sorts of decisions? And perhaps that is beyond their reach, that they're unable to function at that high level, even though they can go out and tend to their garden and do other things and drive their car. What this really does, to my way of thinking, the thing that I've been enamored with the substantive part of this is that it allows for a customization and gives the judge and the parties and the families and the lawyers more tools in our toolbox to really get to the heart of the matter. Let me give you just a couple of examples. I worked on a case that involved a very successful businessman, and he was still the president of his company. And he had a lot of lieutenants that were running that, but he's the one that's putting the deals together, right? He's the one that's out there raising the money. And he fell prey to a series of scams. He was an older individual and ended up losing a substantial amount of money, well over $1 million. So, the children step in to try to take control of this situation, and, he's sending, all this money to these scammers. And the question is, are you going to take him out of play? right? He's the president of his company. He's contributing to his community. When really what the problem is somebody needs to be able to step in and in a very narrow way, take control of his ability to fall prey to these scammers. And we ended up devising something that I've lost touch. I actually mediated that case to know how the rest of the story turned out. But to have adjudicated him as an adult with an impairment in a public proceeding, in a public way that anybody can get on their computer and see would not benefit anybody. In order to take control of the situation and keep him from being scammed or falling prey to this sort of a situation is something that the court should have been able to get in and entertain, but we don't have that system under the existing law. You're either an adult with an impairment or you're not an adult with an impairment. And it's important to remember when you're looking at this in the continuum, when you're looking at a guardianship or a conservatorship type standard under the new law or under the old law, it is a longitudinal study. So it is not a cross-section in time. It is day in and day out, is this individual able to perform at a certain level? Are they able to keep their checkbook balanced? Are they able to make sound medical decisions? Are they able to do these things? So, and it is not defined by a socioeconomic group. We've had business owners. I have represented spouses of medical providers before that are still able to provide medical services to patients, but they've got deficits in other parts of their life. And the flexibility that UGOPA would give us as practitioners to assist these families with the other protective arrangements is of great importance. The other thing that as we've studied this, and I certainly have seen this, I just worked on this case in the last year where this woman gets diagnosed with a brain tumor, and she's an older lady. She goes in for brain surgery, and by the time it's time for her to be moved to rehab, she discovers she's got a guardian, she's got a conservator. Her house out west has been, like out west Kansas, has been cleaned out. Her conservator has boxed up all of her stuff and put it into a storage unit. And so she had to hire me to go in to petition the court to restore her to capacity. But that's how quickly you can lose control over something like this. You think about the little old person that falls, they break a hip, they've got a urinary tract infection. So they're not scrambled, they're not thinking clearly, they're not making the best decisions, and there's no mechanism in place right now for the court to go back in and take a look at 90 days or 60 days. Is this really a level of care that is necessary? And UGOPA will provide that has to happen. And, as a part of the hospital industry, in order for them to make money, they've got to have patients in beds. And if there aren't enough beds and they need to move patients out, the hospitals are going to pay lawyers to come in and file these guardianships and conservatorships in order to get the patients out of their hospital and into a nursing home or into a rehab facility. Is that long-term something that needs to be done? I've worked on cases where it's not. And so, I understand the economics and understand getting people moved from one phase to another, but oftentimes this can be a transitional sort of situation. The Jurisdictional Act, to me, is a no-brainer. I don't know whether you all are aware of this. I have worked on, not 10, but probably close to 10 parental kidnappings, believe it or not. And I mean, the cases just almost always fall into this pattern where you've got a second marriage or some type of a subsequent marriage. The kids are grown by the time this relationship blooms between these two older people. And all of a sudden, you've got the kids coming in and kidnapping mom or kidnapping dad. And before you know it, dad's in Texas or mom's in Missouri, and the kids are filing a guardianship or a conservatorship in Texas or Kansas. And they're filing a divorce from the spouse because they're, well, I won't ascribe the motives, but usually it has to do with money. And there's no mechanism without this jurisdictional act to sort out between the state of Kansas and the state of Missouri, or the state of Texas and the state of Kansas, who has jurisdiction over this individual. What, in fact, is their home state? Okay, I mean, we do this for kids. We don't do it for our elderly. And so I've seen that as a problem. The other thing that the Jurisdictional Act does that I think is really something that we need here in Kansas is that it allows the resident of Kansas City, Kansas, for example, who owns real estate in Missouri, because Missouri has a jurisdictional act. We're one of 4 states out of 50 that doesn't have this. So, in Kansas, if a judge orders that property be sold in Missouri, Missouri is not going to give full faith and credit to that order. The Jurisdictional Act would permit that to occur. Right now, we would be required to go file an action in Missouri to get a Missouri court to permit the sale of that. When this individual, the court has already exercised jurisdiction. So I think that they're both very good acts. I think that we need a fresh look. We need a fresh break. I think that the Judicial Council has approved all of these acts that have come out of our committee's work, with the exception of the end-of-life decisions. And I think that my testimony addresses that. And I think that we've got several opponents that we heard from. And I'll take off my hat now for the Judicial Council. We are leaving that to the hands of the legislature to make a determination. Our committee looked at it, and we've got 3 things that we think are appropriate. I'll tell you, in the 1,000+ cases I've worked on, maybe I've gotten orders in 20 or 25. And so it is not something that happens all the time. It is a matter of gravity, and oftentimes when it happens, there is an urgency and there is suffering going on with people. And so it is not a situation that I want to see an individual that needs a court order in place to be denied that court order, to allow that process, that death process, to take place while a patient is suffering. So with that, Madam Chair, I don't know if you want to wait for questions until after the proponents, or...
Yep, I think we'll hear from Michelle Reichert. She's going to be here WebEx, and then we will, if you can stay for a little bit, we'll ask. Okay, thank you so much. Cole, do we have Michelle online? Okay, on WebEx. So, hi, Michelle. Welcome to the House Judiciary Committee. We have your testimony in front of us. Are you there?
I am. Can you hear me?
We can hear you, and now we can see you. Okay. Thank you for being here. Welcome to committee.
Thank you, Madam Chair, honorable members of the House Committee. The Department of Defense is grateful for the opportunity to support the policies reflected in this bill. My name is Michelle Richard. I'm the Midwest Region Liaison at the Department of Defense State Liaison Office. I'll keep my comments brief as I submitted written testimony to the same. Kansas is, this House Bill 2359 is a crucial piece of legislation that would bring much needed uniformity to guardianship laws in Kansas. This bill directly addresses the challenges faced by military families relocating to the state due to permanent changes of station or other mission requirements. Kansas is currently only one of 4 states not a party to the Uniform Adult Guardianship and Protected Proceedings Jurisdiction Act. This lack of uniformity places undue burdens on military families with adult dependents, forcing them to navigate a complex and costly legal process each time they relocate. Average military family moves every 2 to 3 years, and this process consumes valuable time and financial resources and also adds significant stress to an already demanding lifestyle. In closing, let me say that we are grateful for the tremendous effort that Kansas has historically given in supporting our service members and their families. We also like to thank you for the opportunity to comment on this important policy change. I stand by for any questions you may have.
Okay, thank you so much. And I think we'll see you again in a minute on a different bill.
Yes.
Okay, committee, what questions do you have for Ms. Perner or Ms. Reichert? Representative Vaughn?
Thank you, Madam Chair. I have a question for Ms. Perner. Just kind of looking at the list of opposition and reading through the testimony, it seems like a lot of people think that this is a good bill, but they have concerns about the end of life powers for Kansas guardians. And I think reading through your testimony, I saw there was discussion about due process and implementation of some of those suggestions. But it looks like maybe the ongoing concern is the actual bill language. And, so it says suffering for the end of life power, suffering from illness or other medical condition for which further treatment other than for the relief of pain would not likely prolong the life of the adult other than by artificial means, nor would restore the adult to any significant degree of capabilities beyond those the adult currently possesses. And I think there's concern that that could apply to folks in the disability community the way that it's currently written. So I'm just wondering, do you have any opposition to changing that language to make it more inclusive? Or if you are, if not, then what is your, what would be the reason to keep it the way that it is, in your opinion, if that makes sense?
Well, the committee, and not the Judicial Council, because the Judicial Council didn't weigh in it, but the committee looked at it and said, look, we think there needs to be a due process hearing. I mean, I'll tell you right now, the existing law does not require it. On 2 of the cases I've worked on, I asked the court to appoint counsel because they were unusual circumstances. And so I think that a court-appointed attorney would be helpful. Disability Rights Center has generously said, we'll make ourselves available. It's one thing if you need to get an attorney because you've got to have a hearing within 72 hours. That attorney's going to have to drop everything, go to the hospital, go to the nursing home, wherever, to meet with the client, report back, have a court hearing. It's one thing if you're in Sedgwick County and that happens. It's another thing if you're in Morton County. I mean, maybe you don't even have a lawyer in Morton County. Oh, I'm about to knock this off. And it changes the standard a bit to clear and convincing evidence for the court, which we thought was adequate. And again, tying back to the suffering issue, that the hearing be held within 72 hours. So one of the very early cases I worked on was with an elderly woman, and her son was her guardian and conservator, and he simply could not bring himself to ask the court for an order to withhold life-sustaining treatment. And this woman was in her later 80s. She had been adjudicated. She coded more than once in the hospital. And finally, I got a call from the social worker, and the social worker said, you got to do something, by not having this order, you are traumatizing my medical staff. She codes, they go in, administer chest compressions, they break her ribs. She codes again, they go in and break more ribs. And so there are circumstances that temporally are going to require the law to act quickly, which, for the lawyers that are on the panel, it doesn't always act quickly. By the same token, I think, by having an attorney appointed as a part of this process, that modifies greatly the process that we have in place now, which really makes it purely a medical decision. You know, you've got concurrence of two doctors, and the judge looks and says, okay, are these two treating physicians? Have they made the appropriate findings? If they've made the appropriate findings, I enter the order.
Quickly follow up.
Go ahead.
Thank you for, I think that expounds upon the changes that were made for the end of life decision. I think those are all good things. I think the remaining concern is just the potential broadness of this definition that could potentially be misapplied to someone, for example, with a disability. So I'm just wondering if you might be in support of narrowing the definition or making it more specific so that that wasn't the case, if that makes sense.
I'm not sure I'm following you on that.
And I'm asking early. I think we'll hear more from the opponents as well. So perhaps it would be an opportunity to work together after we hear from both sides to take a look at that. But so I guess maybe I'll wait until that time.
Do you
if that makes
plan on
sense.
staying for the rest of the hearing? Are you able to stay, or do you need to run out now? Because we'll have a little bit of the opponent testimony, and then if Representative Vaughn had a further question, maybe she could ask it then.
And I'd be more than happy to stick around until
Okay.
the opponents are done.
Okay, thank you.
Thank you.
Okay, any other questions? Okay, thank you so much. Oh, I'm so sorry. Go ahead, Representative Carmichael.
Thank you very much, and I appreciate the chair's suggestion that Ms. Perner have an opportunity to listen to the testimony, and that will save me having to ask a hypothetical based upon their testimony that I haven't even fully read. So that will shorten it up. Thank you. But there are a couple things I need mention. Number one, as I'm sure the chair knows, Ms. Perner is far too modest. She is one of the leading attorneys in this state on this topic, amongst the preeminent lawyers in this state, and the friendly competition, if you will, of some of my former partners too. And I'm honored and glad that she's here today. That being said, during the course of your testimony, you made reference to kidnapping the parent by the kids to get them away, perhaps from a new spouse. That phenomenon, though, also works the other way, I think, that sometimes the new spouse may, quote unquote, kidnap dad and take him off to who knows where, and arguably hasten his death to get to the proceeds of the estate. So I think you know in your experience, I think we've even worked on cases of that. But it goes both ways, does it not?
It does go both ways. And I worked on a case about a year and a half ago where, again, it's one of the children. I haven't worked with the spousal kidnapping yet, but one of the children.
I'm sorry, it was the El Khoury firm that was involved. Never mind.
Well,
just go ahead. I'm delaying. I apologize.
Yeah, no, where mama, who was 90-something years old, lifelong Kansan. One of the kids took her to Washington and filed a guardianship conservatorship up there. And the state of Washington has this jurisdictional act and Kansas doesn't. You know, so there's no ability for the courts to confer with one another to really get to the meat of which court does this belong in, you know? Really gonna, so.
My second question, with the chair's leave, is we have had discussion in this legislature in prior sessions about assisted decision-making agreements that are described as a streamlined procedure that avoids conservatorships, guardianships, etc. Did the council look at these issues? Are they included in the report, the legislation, or am I hitting you with something you've never heard of? Because I expect you have.
Well, and actually that's assigned to our committee. At our next meeting, we're going to be discussing that. But to my way of thinking, UGOPA really swallows up a lot of the need. And I think it gets around some of the objections that we've run into.
UGOPA being the Uniform Guardianship, et cetera, Act we're talking about here.
Right, because
Go
you've
ahead,
got
please.
a court that's able to enter a very specific order. So for the little old person that needs to leave Wesley Hospital and go to the rehab center or go to the skilled nursing home, the court can go in and appoint somebody just to do that task. Or if you've got the assisted decision-making, you can go in and take just a little slice of that without taking the whole bundle of sticks that comprise that person's individual rights. So I think it is going to take, we're going to need to take a bigger look at all of that. And it makes me really wonder whether or not the supported decision-making is going to be necessary if we're able to get this act up and running. And, you know, the bankers, of course, have got big concerns about that. I think the Kansas Bar Association does, because
But we can save that for the next report and
exactly.
possibly. That's good enough for me
Exactly.
today, Madam Chair. Thank you. I didn't mean to
Okay.
cut you off, my friend, but.
No.
Thank you. Okay, thank you. I think we'll go ahead with the opponents now. Committee, I do want to draw your attention to written-only proponent testimony from the Office of the State Long-Term Care Ombudsman. Okay, opponents, there's a number of you. I'm going to limit your testimony to 2 minutes. I think you may have similar things to say, so please just keep that in mind in your testimony. And we will first call up Chuck Weber from the Kansas Catholic Conference. Welcome to committee.
Thank you, Madam Chair, and good afternoon, committee. I'll be trying to stay within my 2 minutes here, but my name is Chuck Weber. I'm with the Kansas Catholic Conference. I represent the Catholic Bishops of Kansas. This topic is of deep concern for us in terms of end-of-life health care, particularly with the IDD community. For me in particular, I have a Down syndrome son, Billy Weber, who is turning 29 years old Saturday. So I'm going to head home hopefully tonight or tomorrow, and we'll have a big birthday party for Billy. But we're stand in opposition to the bill, I would say temporarily, or with hopes that the amendment that we have been working on for some time is drafted in its entirety, or at least in most of its entirety. So I will leave it at that. I mean, my colleagues and I are working together, DRC. You're going to hear from some people that are much more knowledgeable about the ins and outs and the legalities of this than I, but we just wanted to register our opposition unless and until the aforementioned amendment is adopted. Thank you.
Okay, thank you. We'll hold questions till, yep, okay. Mike Burgess from the Disability Rights Center of Kansas, welcome to committee.
Thank you, Madam Chair. And Rocky Nichols, the Executive Director of the Disability Rights Center, is also here. So if we get to questions, he initially wasn't going to be able to be here yesterday, so you get me. But if there's questions, he has more expertise going into the Wayback Machine as far as the history of this. So as in my, definitely not going to read my testimony in 2 minutes, but there's a lot of good things in this underlying bill. There's one piece that we really think is a significant flaw. And as the conferee earlier explained, I mean, there's a lot of good positive pieces around the appointment of counsel, around requiring a hearing. Those were all positive pieces. The peanut to all of this and the problem, and I'll jump to this, is the language that's in on page 3 of my testimony. Unfortunately, the criteria for when this can be triggered and when that hearing and when the counsel will come into play is what determines this. And so physicians sign off to say, does this patient meet these criteria? And that criteria is that further treatment other than for the relief of pain would not likely prolong the life of the adult other than by artificial means. Nor would restore the adult to any significant degree of capability beyond those the adult currently processes. And so in my testimony, there are 4 examples of an individual who may be able to live for years and years. They are not in the dying process, but due to this criteria that are out there, they would meet that criteria. So a physician would sign off to say, yes, this person meets that criteria. And so what we think would be a better option, and this will again be in the form of an amendment, is to say suffering from a severe illness and that life-sustaining medical care is objectively futile and would only prolong the dying process. So we're bringing it back to where they are in the dying process, not the fact that they have a disability. And so that's the specific piece. And that's, you think kidney dialysis. It could be somebody that eats with a feeding tube. It could be an iron lung. There's a number of situations where people have gone on to do extraordinary things despite having those things. But if they happen to have a guardian, and that guardian wanted to petition to get like a do not resuscitate order in place, which happened with one of the people, and there are situations where that would be appropriate. I'm not trying to say in a blanket, but if they fit this other definition, like the example with the rib cracking, that's an example that I would think, a medical or a physician would be able to objectively say, yeah, that meets that criteria. With the hearing within 72 hours, the timeline, we're very sensitive to that issue. But we want to see that it doesn't accidentally encompass or arbitrarily encompass somebody just because they have a disability. So that's the peanut. I would love to go more, but due to time, I will definitely limit it and would be happy to Rocky and I would be happy to answer questions at the appropriate time.
Okay, thank you so much. Next, we have Shane Lewis, Self-Advocate Coalition of Kansas. And I think that's WebEx.
Yes.
Shane,
Hello.
are you with us?
Can you hear me?
We can hear you, yes. There you are. Hi, Shane. Welcome to
Hello.
committee.
Thank you. My name is Shane Lewis. I work for the Self-Advocate Coalition of Kansas, and we like this bill. We're just concerned with quality of life issues, and I think if we go with as being a part of Big Tent and those kind of things, I think if we go with DRC and plans to amendment the bill, I think we would be just fine, and I think people with disabilities would appreciate the bill, and I think it would help people who are under a guardianship or conservatorship, as long as it's amended for the quality of life issues, and it would help people with disabilities.
Okay, thank you so much. We really appreciate you coming to committee. Thank you.
Have a nice day. Thank you.
Thanks. Okay, next we have Jean Gowden from Kansans for Life. Welcome to committee.
There we go. Thank you, Chairwoman Humphreys and members of the committee. I'm Jean Gowden, Director of Government Relations with Kansans for Life, and I appreciate the chance to explain our opposition to House Bill 2359. As the conferees have said before, we commend the guardianship, the Judicial Council's guardianship advisory committee for the hard work that it did to look at the current guardianships and conservatorship statutes. We just have, with the other conferees who are in opposition, we have a serious concern with the section that deals with the language of withholding or withdrawing life-saving or life-sustaining medical care. Back in 2007, Kansans for Life did support legislation that would have corrected that life-threatening language, but unfortunately the bill did not pass. So last year, the groups came together, the Disability Rights Center of Kansas, Kansans for Life Catholic Conference, Kansas Council on Developmental Disabilities, and the Big Tent Coalition to express our mutual concerns to the Guardianship Council, the committee. And we gave them some suggestions for how to correct the language to make it more protective for folks. But the Judicial Council it ultimately did not endorse that section of the advisory committee's report. And so they said, and we agree, that it is the role of the legislature to be able to develop the language and the appropriate definitions for that particular section. So we feel it is the grave responsibility of this committee to structure the law to protect the lives of Kansans with disability who may not possess a worthy guardian at the time their lives are in jeopardy. And so we encourage the committee to support an amendment to 2359, which will correct the life-threatening flaws in the language currently used regarding withholding or withdrawing nutrition, hydration, medical care, and add the necessary definition. So until such time as that language of the amendment is added, we must oppose the bill, and I thank you for your consideration. I'll stand for questions.
Colin, if you could unmute, that would be helpful.
Hi,
Okay,
my
there you are.
name, all right, yes. My name is Colin Ornick and I'm representing the Big Tent Coalition. Basically, we're a consortium of disability and other advocacy groups for people with disabilities, elderly, and I believe people below income. We support everything in the bill except for the end of life provisions, which deal with the definition, which Mike Burgess already told you about. And we remain in opposition until their amendment, until it is amended, as DRC and other groups are working with the reviser on. And I will stand for questions at the appropriate time.
Okay, thank you, Colin. We really appreciate your point of view. Thank you, and we'll see if we have any questions at the end of the opposition. Thank you. Okay, Whit Downing, the Kansas Council on Developmental Disabilities. Welcome to committee. Are you here, Whit? Okay, maybe Whit. It will be written only. Don't see him. Okay, are there any other, well, let's ask questions of the opponents, I guess, right now. Representative Carmichael, you have a question? And if you'll just say who the question is for.
I think I can accommodate those requests. First, I do need to mention that I always appreciate hearing from Mr. Olnick. His testimony has been very valuable in these matters. Two questions, I hope, and I make it quick, is Ms. Godden, I have a quick question for you about the amendment that you discuss. I know the Disability Rights Center has an amendment in process with the reviser. Is your proposed amendment different? Is it forthcoming? Help me know, because we may work this tomorrow and I just need to know what to look for.
Thank you, Madam Chair, and Representative, great question. And yes, we are, all of the groups that have been working together, it is one amendment and we support it fully.
Thank you very much. That makes our job easier. If I might, thank you. I don't know when we get back to Ms. Perner, but I would like for her to have a chance to address in particular Mr. Burge's testimony and get their
Okay, let's see if
response.
there's other questions for the opponents first, and then we can.
Yeah, I just want to make sure we get that discussion because
Okay,
I think it's important.
Okay, committee, any questions for the opponents? Any other questions? Okay, so Rachel, if you could come up and just give us your thoughts about what you heard.
Okay. I have not seen the amendment yet. I know that the report that came to the committee, that we had this informal meeting, and it was, I think, a good meeting and a lot of frank conversation. The two-page memo that came was really kind of a non-starter for the committee. There was a differing burden of proof in it and some other things that I think really didn't accomplish. So I can't really speak to what they're proposing because I haven't seen it. Of the end-of-life decisions that I've made outside of aging decisions, I'm trying to think. I did work with one individual that was in his 50s that we secured an order, and he was, I think I shared this with you, Mr. Weber, when you came and addressed the committee, that he was a Down syndrome child that had lived well beyond, his expected lifespan, but was to a point in his life where they would fix one system and the next system would shut down, and they'd try to fix that one and the next one would shut down. So it was from kidney failure, from liver failure, et cetera, et cetera. And in that instance, even though I wasn't required to do so, I had the court appoint an attorney because he was on such the young side of life. So I don't know whether that answers anything. I haven't seen.
Madam Chair, my specific question, if I might, of Ms. Perner is that Mr. Burgess, in conversation earlier, told me that the subject matter of their concerns with the bill was a matter that the council and the committee said was a matter of policy for the legislature and not something that they were issuing recommendations on. Does the Judicial Council's recommendation cover the subject matter as at least was described in Mr. Burgess' testimony? Because none of us have the amendment yet. Mr. Thompson works very hard, but we probably won't see it till sometime tomorrow.
We haven't seen it. Our product that came out of the committee that was not approved by the council is the language that's in the bill currently.
Still terribly confused, but I won't take more
I
time.
might can help a little bit about that. So I do think, 2 points. I think a lot of the amendment is the definition. So maybe you've seen part of that definition rework, or maybe you haven't, I don't know. And then the other thing is I know that the burden of proof, they changed to clear and convincing in there. So that was an important piece. So yeah. Okay, if I may just offer a little bit of explanation here. The Judicial Council had an advisory committee that Ms. Perner was on that worked for 4 years or so on this and reworked everything. And then they made a report to the Judicial Council, and on Ms. Perner's letterhead, it shows you who's on the Judicial Council, actually. And so we got a report from your advisory committee, and we accepted the report except for that piece of end of life. And it's my recollection that the Judicial Council said on this piece, we'll let the legislators, this policy piece will be for the legislators to decide.
That's consistent with what Mr. Burgess relayed to me. I just did not enunciate it correctly.
And does
Clearly.
that make sense to you also?
It did.
Okay. All right.
Chairwoman.
Okay, thank you. Any other questions for opponents or for Ms. Perner? Okay, thank you so much.
Thank you all again for your public service. It's a sacrifice, and we appreciate it, even though we in the public, sometimes you might not think we do. So.
Thank you. And we do have neutral testimony from Joan Kelly, if you would come forward. And I'll just ask you to kind of keep it to 2 or 3 minutes, please. Thank you.
Thank you for the opportunity to represent those with the most profound cognitive deficits, our most fragile citizens. My name is Joan Kelly, and my husband and I are co-guardians with over 30 years experience, firsthand experience, in assuring that the proper supports are in place for our grandson, Aiden, now age 34, who still functions cognitively at the infant toddler level. The National Council on Severe Autism is one of several national organizations representing profoundly affected individuals. We appreciate the extensive work of the Judicial Council and their graciousness towards us, and as well as the work of this esteemed committee. We respectfully request careful scrutiny by the committee to identify and to close any loophole interpretation in proposed changes that would create a slippery slope of capacity for our loved ones who have been adjudicated incompetent. Our lifelong and intimate knowledge of our loved ones promotes us to ask this of this committee, to seriously consider this subset of the DD population, which is often ignored in policy making. And without going into much detail about that, I will just tell you that the American Bar Association portrays guardianship only in a negative sense and gives absolutely no credit to the majority of guardians that makes lifelong sacrificial investments for their loved ones. Our attorneys and those with legal background also made a number of appeals to the Uniform Law Commission over the course of several years. We've requested a seat at the table, and every single request by the ABA and the Uniform Law Commission has ignored our request. Now, this came from their peers who are also attorneys. I think it's astonishing that that occurred. Because both the ABA and the Commission's silence, I'm compelled to implore every person on this committee to find 6 minutes out of your extremely challenging schedule to just look and see what our families face. And I will just mention also that our amendments that we've submitted were created mostly by attorneys who have lived the realities on the ground of caring for and making lifelong decisions for the most challenging and fragile among us. And with that, I'm going to close. I just will tell you that if anyone doubts any of my allegations or statements here today, I'd be happy to share with you how we are often not given a seat at the table in ideological policy making and how we have not been recognized. And I'm out of consideration, I'm going to close, but I am happy to answer any questions at the appropriate time. Thank you.
Thank you for being here. And I should have mentioned that your organization is a National Council on Severe Autism. Thank you. And committee, there was a problem with getting that testimony on the S drive, but we will get it on the S drive, so you can be sure to take a look at it, please. Okay, in regards to that, do you have any questions for Ms. Kelly? Anybody? Or neutral testimony? Okay, thank you for being here. Thank you for what you do. Appreciate it. Okay, so with that, we will close the hearing on House Bill 2359. And thank you everyone for being here. We appreciate all of the conferees for being here with us, but we will close the hearing and we will move on to the next hearing, which is House Bill 2242. And we will have our advisor give us a bill brief on House Bill 2242.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So House Bill 2242, a little bit different than our normal subject matter here. It concerns federal jurisdiction. It authorizes the governor to accept requests of concurrent jurisdiction from the federal government in certain circumstances. For myself and for the committee, I had to kind of put this one in context. So the amendment here is to KSA 27-102. That's the statute that provides for federal jurisdiction over land acquired by the United States pursuant to KSA 27-101. The current law just sort of provides that exclusive jurisdiction over the lands that are applied there, or the lands mentioned there, is ceded to the United States with some exceptions for serving process and taxation, some things that were reserved by the state of Kansas. So the new subsection here, subsection B, beginning on line 19 of page 1, provides that the state authorizes the governor to grant requests from the United States to establish concurrent jurisdiction over land owned by the United States for military purposes within the boundaries of Kansas. That jurisdiction will be effective upon completion of all the requirements of the section. I won't read those to you, and you've got some folks that'll kind of go into detail about why those would be important, but that's the peanut of the bill and what it would allow the governor to do.
Okay, thank you. Committee, do you have any questions for the revisor on House Bill 2240? Okay, thank you. Okay, we will go ahead with our proponents. We have Michelle Reichert, who we've seen one other time today. She's on WebEx. Welcome back to committee.
Thank you, Madam Chair. Honorable members of the committee. Again, my name is Michelle Richard. I am still the Midwest Region Liaison at the Department of Defense, the State Liaison Office. Just to give you a little background, like our office educates and informs state policymakers on issues affecting quality of life of military families. My region includes 6 states to include Kansas. And again, the Department of Defense is really grateful for the opportunity to support the policies reflected in this bill, which addresses concurrent jurisdiction on military installations. Some additional background. In January 2018, the Wyoming Law Review published an article by Army Officer Lieutenant Colonel Rob Levine on the need to establish concurrent jurisdiction on military installations to protect our children. This article references an egregious case which occurred at Fort Lewis in the state of Washington, where a 7-year-old boy was raped by a 13-year-old in a wooded ravine near his home on post. Now, because the state of Washington had ceded exclusive legislative jurisdiction to the federal government over the lands that would then later become Fort Lewis way back in 1917, the state of Washington cannot subject the juvenile offender to its laws. And unfortunately, the federal system lacks an effective mechanism for handling juvenile offenses. Without concurrent jurisdiction, there's a black hole for juvenile justice on federal installations. Federal prosecutors routinely decline to prosecute juvenile and juvenile sexual assault cases, and local prosecutors lack legal authority to apply state laws to juvenile criminal conduct on federal lands. To be clear, these cases are rare, but no less important. The military services, Air Force and Army, Space Force, Navy, have been tasked nationwide with offering concurrent jurisdiction back to the state over juveniles. Our office at the Defense State Liaison Office has been working throughout the country with state policymakers to ensure that it is possible for the military services to offer such jurisdiction. As such, this is a nationwide effort. Over the past few years, a number of states have passed or are currently considering similar pieces of legislation. In my region, last year, Colorado, Nebraska, and South Dakota passed a similar policy, and North Dakota is currently considering it. Currently, Kansas has no mechanism in state code for the federal government to offer concurrent jurisdiction back to the state. Importantly, this policy as proposed does not automatically confer concurrent jurisdiction, but rather it makes it permissive and opens the door to negotiations between the state and the military installations. In other words, this law remains dormant until a number of elements are met by both the federal government and the state of Kansas. In addition to establishing a general process for retrocession, the proposed policy change includes a statutorily supported memorandum between military installations and state officials. Under this paragraph, the state and installation would then together define the working relationship to support activities associated with concurrent jurisdiction once it is established in law through this proposed policy. This bill is critical to the welfare, or critical to preventing adverse impacts to the health, safety, and welfare of juveniles and the military community. As representative of the Department of Defense, I'm before you today to ask for your assistance to ensure that concurrent jurisdiction over juveniles may be established for federal military installations in Kansas. We do have someone, I believe, from McConnell Air Force Base who can speak to the impact at McConnell. And if I may take just a moment and be so bold, I would also wish to ask committee to consider House Bill 2243. This bill has been referred to the committee and has not been set for a hearing yet. It is also related to the welfare of military children. Specifically, it involves a referral of military children and their families to the Department of Defense's Family Advocacy Program when they are involved in a child abuse or neglect investigation. The purpose is so those families, the vast majority who live off the installation, can have access to additional resources that are available at the onset of an investigation. We are grateful for the tremendous effort that Kansas has given in supporting our service members and their families, and wish to thank Representative Proctor for introducing this policy change. And with that, I will stand by for any questions that you may have. Thank you.
Okay, thank you. We will go ahead and hear from the other proponents, and then we'll see if there's any questions. Now we have Lieutenant Colonel Michael Ramming from McConnell Air Force Base, also on WebEx. See you there?
Can you hear me?
We can hear you. There you are. Welcome to committee.
Thank you, Madam Chair and honorable members of the House Committee on the Judiciary. My name is Lieutenant Colonel Michael Ramming. I'm the Staff Judge Advocate for the 22nd Air Refueling Wing, which is the host unit for McConnell Air Force Base. And joining me here to my right is Mr. Jonathan Sullivan, who serves as the Chief of Civil Law in the McConnell Air Force Base Legal Office. And on behalf of the installation commander, we greatly appreciate this opportunity to provide a little information regarding House Bill 2242 and this potential to allow the retrocession of exclusive federal jurisdiction to a concurrent state and federal jurisdictional arrangement. Asked to testify just because I wanted to inform the committee that McConnell Air Force Base is in fact seeking to modify our current exclusive federal jurisdictional scheme to one of concurrent state and federal arrangement. Thus far, as we've been working with community partners, we have obtained concurrence, if my tally is correct, from the Sedgwick County Sheriff's Office, the Sedgwick County District Attorney's Office, the Wichita City Attorney, and the United States Attorney's Office. And the primary concern is the situation surrounding juvenile offenders. We do enjoy a positive and productive relationship with the U.S. Attorney's Office when it comes to addressing allegations of civilian misconduct here on McConnell Air Force Base. But should there be an allegation of a serious juvenile offense, we simply don't have the same tools at our disposal for both juvenile justice and juvenile rehabilitation that our community partners in the state system have at their disposal. And we did submit a request for Mr. Sullivan's testimony as well. And with your leave,
we have that on our agenda. So thank you, Mr. Sullivan, for being here. Go ahead. We'd love to hear your comments.
Thank you, Madam Chair. And in my role as the Chief of Civil Law here at McConnell Air Force Base, the legal office, I also serve as a Special Assistant United States Attorney. And that currently allows me to prosecute civilian misdemeanor offenses that occur on McConnell Air Force Base. It's being magistrate court before a federal magistrate. And that's on behalf of the United States Attorney's Office. And it also makes me the de facto liaison to them. And prior to taking the position here at McConnell, I served as a juvenile prosecutor in the Sedgwick County District Attorney's Office for 22 years. And the federal criminal justice system, it doesn't have the same options to address juvenile criminal behavior that the Kansas state system has. And in an extreme case in the federal courts, the U.S. Attorney could seek to prosecute a juvenile as an adult for a very serious crime, but the federal system basically does not have the mechanism or the tools available to rehabilitate and prosecute juvenile offenders. And thankfully, we have not faced that situation in McConnell, but obviously it does happen within the Department of the Air Force and throughout the DoD. And if the legislature passes this bill, it opens the ability for McConnell Air Force Base to work with our local community partners to ensure that our military community is as safe as possible and that any alleged juvenile offenders are afforded a fair process in a system that is properly designed to protect their rights, protect the rights of victims, and properly balance punishment with juvenile rehabilitation and the event of a conviction. And I also would like to expand on, I talked to Colonel Raymond about this. We also, with a concurrent jurisdiction, we've discussed this arrangement with our local partners. Even adult offenses that could best be suited to be prosecuted in a state court rather than a federal court, so like domestic violence offenses, yes, they can be charged in federal court, but the mechanisms are different, obviously. For a federal charge to come forward, there has to be an indictment done. That's a bigger process. And basically, the way things would operate is we would convene with our partners, with the U.S. Attorney, with the local prosecutors, and decide where a case would best be suited to be prosecuted. By having concurrent jurisdiction, we could make that decision among ourselves at the local level and decide where a case is best prosecuted, who has the best resources. And specifically, it is the juvenile offenses that are driving this discussion and request, but it also would apply to adult offenders as well, where we could determine what court system would be best suited to actually prosecute an offender, be that at the state or federal level. Thank you.
Okay, thank you both for being here. We'll see if the committee has any questions for the proponents. Representative Carmichael.
Thank you, Madam Chair. Probably best for Mr. Sullivan, but I'm happy to hear from Lieutenant Colonel. When I was very young, I used to listen to federal magistrates hear cases under the Assimilative Crimes Act, which generally allowed federal prosecution in the federal court for events occurring on military reservations based on the state law of the adjacent jurisdiction, as I recall. Is that still the law? And why doesn't that serve your needs? And I think I know the answer, but I better ask you.
Yeah, yes, sir. That is still the law, but actually in the magistrate court system, obviously we can only do misdemeanor offenses. The U.S. Attorney could use the Assimilated Crimes Act, but specifically we're talking about with a juvenile offender, there's no rehabilitative processes or tools that the U.S. Attorney has available that are comparable to the state level. And the state.
Go ahead, I'm sorry.
Oh, and obviously, as I said, I was a juvenile prosecutor for 22 years in Sedgwick County, and we have obviously a very robust juvenile court system. And basically the apparatuses in the supervision in state court and in state processes is so much more robust than what like the U.S. probation office would have. They don't have the tools to supervise juvenile offenders. They have the tools to supervise adults, but they don't have the ability, like say, if we have a juvenile offender in magistrate court or even federal court who's on probation, they can't be detained in a county jail, and there would be no process to put them in, like say, the Sedgwick County Juvenile Detention Facility, or
Quick follow-up, Madam Chair. But this bill is not just confined to juveniles. This bill that we're looking at is adults as well as juveniles. Do I understand that correctly?
Is that for Madam Chair?
No.
Oh, that was intended for you. I'm sorry.
Oh, I'm
Mr.
sorry.
Sullivan.
Yes,
I was
it
just
would
apologizing
be-
to the chair for asking a second question without permission.
I'm sorry. No, it would be intended for adults and juveniles. And the apparatus is contemplated, specifically I can speak for Sedgwick County, is that the magistrate court system, I would still prosecute civilian misdemeanors in magistrate court, but if we would confer with the U.S. Attorney and the local district attorney to make a determination is like, okay, where would this case be best be prosecuted? If someone, obviously we're not talking federal crimes like espionage, treason, that sort of thing, sensitive things that the federal prosecutors would definitely take. Like I referenced domestic violence, civilian on civilian crime in like say our base housing facility. And I know Fort Riley is dealing with this right now. They had to indict a civilian in federal court for murdering a soldier. And that case is still going through. And Mr. Richard may have some background on that, but I know that case is still going on. And so whereas a murder case may best be suited to be charged in state court rather than federal court, if that's because the victims may all be local and we don't want to use the federal apparatus to prosecute someone. It's just basically, having concurrent jurisdiction allows the prosecutors and the law enforcement officials to then confer and decide where would a case be best suited to be prosecuted. Obviously, it's the juvenile offender piece that's driving this because that's where basically state courts are best suited to deal with those.
And I think
Thank
Ms.
you.
Richard has a comment now too. So did I see that she raised her hand?
Thank you, Madam Chair. Just to give a little, can you hear me?
Yes, we can.
Thank you. Just to highlight that some states have a retrocession statute. Other states do not. And states that have a retrocession statute, for example, Nebraska and South Dakota, the Department of Defense requested that we add juveniles into the existing statute because juveniles are considered a separate area of law. Because Kansas does not have any retrocession on the statute or on the state code, on any statute at all addressing retrocession, there's no process at all to for the federal government to even offer to the state jurisdiction. The state can always say no, but there's no process to offer jurisdiction. In working with the bill sponsor, we thought it would be best practice to then set a general process, which is why this is inclusive of all areas.
Okay, thank you. That makes sense. Okay, any other questions for the proponents? I'm going to just say I think that at this point we'll go ahead. I see that hand raised. So Cole, who is that hand? Oh, that was her hand. Okay, great. Okay, perfect. That's great. Okay, thank you. All right, thank you so much for that. Committee, with seeing no further questions, we will cease questions of the proponents. I do want to call your attention to Lieutenant Colonel Keith Marshall from the Adjutant General's office here in the Kansas National Guard. And with that, we will close the hearing on House Bill 2242. We do appreciate all of the proponents that came by WebEx. Thank you for that. Okay, and committee, we have one hearing left. You're doing a great job. I will now open the hearing on House Bill 2253, and we will have Jason give us a bill brief on that one. Thank you.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. So House Bill 2253 gets into a little more familiar territory. Crimes, punishment, criminal procedure, in particular the crime of theft. That's KSA 21-5801. I kind of highlight for you the current law penalties, which you can see start at the bottom of page 1. $100,000 or more in value is a level 5 and goes down from there. 7, 9, Class A person misdemeanor, non-person misdemeanor if it's $1,500 or less. So what the bill does is instead of based on value of property, adds a subsection specifically for property that is livestock or an implement of husbandry, and just makes it always a severity level 5 non-person felony. So rather than the value-based system, it's about what kind of property it is. And you'll notice in the subsections between the value and that new subsection, there are others that do similar sorts of things. So we just followed that same model. I know livestock means the same as defined in section 2 that's in the bill, and then implement of husbandry means the same as a definition in the transportation statutes. So I gave you that on page 2 of the memo, so you don't have to go look it up. I did that for you. Then, as I mentioned, section 2 amends KSA 22-4807A. That's a criminal procedure statute that authorizes forfeiture in the very specific case of theft of livestock. So we have a special criminal procedure statute just for forfeiture of property used in the theft of livestock. And no amendments are really made to the process or the kinds of property. What's added is theft of implements of husbandry are added throughout the section to go along with theft of livestock. So that's about as quick as I can do it. I'll be happy to answer questions.
Okay, committee, what questions do you have for our revisor? Representative Carmichael.
Thank you very much. I thought this was a livestock bill. But when I see implements of husbandry, I'm not a K-State grad, but it refers to a statute. What is husbandry? I think I know.
Representative Osmond.
Madam
Jason,
Chair.
do you know what the, yeah.
Yeah, Madam Chair, Representative. So page 2 of the memo, I included after the effective date, that's July 1st of 2025 that I didn't mention, KSA 8-126, the definition there. It's farm tractors, self-propelled farm implements, fertilizer spreaders, et cetera. There's a whole number of
Thank you.
vehicles and such, yeah.
Okay, thank you. Committee, any other questions for the revisor? Okay, thank you. We have a host of proponents. We will ask you to keep your testimony to 2 minutes, please. And we will go ahead and call up Ron Sieber on the Kansas Grain and Feed Association. Welcome to committee. We don't see you in Judiciary very often.
Madam Chair, I have our state representative who would like to one-up me and speak first, if that's quite all right.
Yeah. Okay, so yes, you may go ahead. Yes, we can change. Go ahead.
Thank you, my chairman.
Welcome to committee. If you'll just introduce yourself. Yeah.
I am Kevin Schwertfeger, the 114th Kansas House Representative, and I'm here today to help present this bill and give some explanation that we didn't, me being new, I was introduced to this bill from the great Representative Steele, who's sitting behind me, and she allowed me to assist. And I did not have everything completed in this bill, so I have an amendment ready for Monday when this bill is ran, but not necessarily today. The amendment is to include the wording and add grain to grain theft, and it is also to include changing the statute that speaks on auto theft as a misdemeanor and to change that as a felony. Because we have an epidemic of auto theft as well as grain theft and cattle theft that is occurring in my district. And my farmers, it's like they're open season on their businesses. And they're kind of fed up. And we need help to try to make this stop. And we cannot ignore this anymore. It is in rather large proportion what's going on. That's the point of my being here. I feel passionate about this. My neighbors, I've submitted testimony to you. I could name 10 different neighbors, and I did write that in my testimony. I have experienced cattle theft myself. I have experienced vehicle theft myself. I've had equipment stolen. And when your neighbor calls you and says he lost 37 head of cattle, how is he going to recover $55,000 worth of loss? How many of you have suffered a $55,000 loss before and just are expected to eat it? How can you recover from that? This farmer worked all year, more than a year, and he has nothing to show for it. And we cannot ignore this. This is just a misdemeanor. Oh, it might add another bed to a prison. Yes, but how can we just ignore this? It's preposterous to do nothing. We have to do something to improve this situation that's ongoing in rural Kansas. We need your help. I beg you to pass this. Thank you.
Okay, thank you so much. Just one second. And so some of the testimony that you have from your friends it's still coming in. Is that what I understand? Yep. Okay. Okay. All right. Thank you so much. And you will have an amendment. Is that what I understand? Okay. Okay, that's great. So I think we'll do them all together. Can you stay, or is that, do you need to go? I know. Okay. Okay, we'll do them all together. Yep, we'll go ahead and do them all together. So now I will call Ron Sieber, but do you like this order? Do you want to go next, or do you want someone else to go?
So, Madam Chair, as a lobbyist, I have 125 bosses in the House of Representatives. So when one of my bosses wants to go first, I'd ask deference of the chair, Madam Chair, if that's okay. Madam Chair, thank you very much, members of the committee, for giving me the opportunity. I am Ron Sieber. I'm the president and CEO of the Kansas Grain and Feed Association. You're probably asking, what's a grain guy doing in Judiciary? Well, as a representative just mentioned, grain theft is a big deal for us. Kansas Grain and Feed Association is the Association of Grain Receiving, Storage, Processing, Shipping within the great state of Kansas. KGFA's membership includes 950 member locations across the state, and as 99% of the commercially licensed grain storage as our members. So you see a grain elevator going from point A to point B, that's going to be one of our members. Unfortunately, at those grain elevators, we see quite a bit of grain theft. It is one of those crimes that kind of goes underneath the radar screen. It's kind of difficult to prosecute because there's often a lot of other things that are get higher priority, such as personal, violent, and like drug-related crimes. However, it's a real thing. And when such theft occurs, the losses can be quite significant for one company to absorb. In addition, it's been proven to secure prosecution, like I just mentioned. So House Bill 2253 is a great bill. It would provide for increased criminal penalties for the crime of theft of livestock and implements of husbandry. In recognition of the difficulty in our industry that we've experienced in prosecuting grain theft, we'd like to see an amendment to the bill to include quote-unquote grain theft. It's hoped it would increase the statutory penalties for the crime and create a new deterrent for the theft of grain. Madam Chair, in the interest of time, I will answer questions at the appropriate time and look forward to it.
Okay, thank you. Appreciate it if you can stay for questions. Next on our agenda is Sheriff Jeff Easter, but I haven't seen him. Is he here?
Yes, ma'am.
Yes, you're on WebEx. Okay,
Yes, ma'am.
wonderful. Yeah, thank you for being here. Nice to see you. Welcome to committee. Go ahead.
Thank you, Madam Chair. I appreciate the opportunity to appear in front of you today representing the Kansas Sheriff's Association on House Bill 2253. You have my written testimony. We do support the change to make this a severity level 5 non-person felony. As you can see, there is a lot of issues with livestock theft. In speaking with Special Agent Jim Penniger with the Livestock and Brand Investigation Unit, last year we've had 3,577 head of cattle, bulls, cows, and calves that were stolen. Total industry value was $3,993,000. One case involved 2 cows valued at $400,000. The second involved 300 cows and calves valued at $650,000. That's just 2 farmers. And so far this year, Livestock and Brand Investigations Unit is working 23 current cases so far in 2025. So this is a big issue. It's a big issue in our rural counties and for our rural sheriffs, and mainly for the cattle farmers that are dealing with this issue on a daily basis. So I appreciate the opportunity to talk to you, and I'll stand for any questions.
Okay, thank you so much. Appreciate you being here. Next, we have Representative Megan Steele. Welcome to the Judiciary Committee.
So I guess Judiciary is going a little.
We are hard workers.
Thank you, Madam Chair and committee members, for taking up this bill. I am writing and standing here. I'm not sure I did bring extra copies of my testimony if you needed it. But this is a critical piece of legislation aimed at addressing the growing issue of livestock theft. It's not just a matter of property loss. It is a direct threat to the livelihoods of hardworking farmers and ranchers across our great state. Before I ran for office this past spring, a close friend of mine experienced firsthand the devastating effects of livestock theft. One morning, he woke up to find 2 of his calves in his trailer had been stolen. The trailer was a backbone for his farm, used daily to transport the hay, the livestock, and supplies necessary. Without it, his operations were severely impacted, forcing him and his family to make difficult adjustments to keep his farm running. Despite reporting the theft immediately, neither the trailer nor the calves were ever recovered. While law enforcement was able to apprehend the thief, the consequences were very minimal, a minor misdemeanor charge. My friend was left to bear the financial burden of replacing stolen equipment while the criminal walked away with little more than a hand slap. After this incident, I began paying closer attention and soon realized that my friend's story was far from unique. Farmers and ranchers across our state have faced similar and even worse situations, with many of them struggling to recover from the financial and emotional toll of these crimes. Livestock theft is not a victimless offense. It disrupts businesses, it destabilizes families, and it undermines the foundation of our agricultural industry here in our great state. HB 2253 is a necessary step toward ensuring justice for victims and deterrence for criminals, strengthening the penalties and providing law enforcement with better resources to combat this theft will protect the people who feed our state and our nation. And I urge you to support this bill, and I will stand for questions now or later.
Okay, thank you so much.
Thank you.
Great timing, perfect timing. Okay, next we have Jackie Gira from the Kansas. I should know what your last name is. I'm sorry.
That's okay. It's Jackie Garagiola. So yeah, if you're a baseball fan, Joe Garagiola, same pronunciation and spelling.
Okay.
But
welcome to committee.
Thank you, Madam Chairwoman. And thank you, committee, for allowing me to be here today to testify as a proponent for HB 2253. I do represent the Kansas Livestock Association as our associate counsel and represent our roughly 5,700 members across the state of Kansas. I won't reiterate too much because most of my testimony has actually been said already by the other proponents. Livestock theft is a huge issue in the state and obviously very personal to our membership. Because of the increasing cattle prices, we're seeing that more and more frequently. And as we've talked to livestock theft investigators, they've noted the increasing difficulty in prosecutors being able to prosecute these crimes under the current guidelines. And so we're asking for increased penalties in the severity of the penalties in order to combat that. And I'm happy to stand for questions at the appropriate time. Thanks.
Okay, thank you so much. Next, we have Josh Pinniger from the Office of the Attorney General. Welcome to the Judiciary Committee. Thanks for your patience.
I'm Jim Pinniger. I'm with the Kansas Attorney General's office. I'm one of the 2 livestock investigators. My partner is Josh Winkler back here. We are funded by the Kansas Department of Agriculture. We receive our commission through the Kansas Attorney General's office. I think about everything I wanted to share has been covered by Sheriff Easter and the other people that are here. I just want to briefly touch on a couple of cases. We worked a case in eastern Kansas. A man lost his entire cow herd. He lost 3 calf crops. The cow herd was around 100 head of cows. His penalty he was found guilty on the felony theft, but he was sentenced to 1 year of probation, and restitution was $50 a month. So those are some of the things we go up against, and our victims, it's devastating to them, their families, their livelihood. Bankers don't have a sense of humor about it when they can no longer pay their bills. So it causes a lot of problems for everyone in the state of Kansas. So if anyone has any questions, I'll be happy to answer them. Thank you.
Okay, thank you for being here. We may have questions if you can stay. All right, we got Representative and Matthew Steele from the Kansas Cattlemen's Association. Are you related to Megan?
Not related, married to.
Okay.
I'm the original Dr. Steele. She's the other Dr. Steele. Yeah.
Well,
Yeah, the one with the gold badge. Yeah. As mentioned, Matt Steele. I'm the CEO and Executive Director for the Cattlemen's Association. So this past year, we've been able to have a lot of conversations with Josh and Jim. They've come and spoke to a couple meetings, and that really got things going with members, and other people were like, well, what can we do? What is this? And that really kind of spurred the drive to start talking to everybody and be like, how does this, and that's kind of how this bill originated, was people started talking together, and it has grown from a conversation with Jim and Josh to conversations with the grain, with KLA. And so that's one of the biggest highlights of this, is it just really brought in a lot of groups, even those that have, are even still interested in what this could be later on as they work and look at what other states have done to secure some of these laws with regards to ag theft. One thing I wanted to point out was, you know, something else is it not only affects the producers, that's a commodity that's now not going out to the consumer. So that one animal, that's 600 pounds of hamburger or more that could not be coming in, or bacon, baby back ribs, all of those types. But also this impacts the urban areas as well. So you think about, if you have backyard chickens in a suburban area, you might be able to have 5 or 6. That's a pretty good little piece of food that's coming into that family. If those are stolen, those don't meet the current requirements for any serious prosecution, where now those small suburban type farms now have some ability to, as well as law enforcement. So it's been a great opportunity this year to really learn about this and work with a lot of great people, from law enforcement to consumers to a lot of different advocacy groups interested in helping everybody out.
Okay, thank you. We'll now do questions. I do have a quick question. You could just stay up. My question is, so when you've seen, a theft of a herd or partial, what is that, you can't recover the stolen property, the cattle? I mean, what happens to that cattle?
So there, and Jim can answer this much better, but I know a lot of these from our conversations is, a lot of times they end up in Oklahoma. They'll take them out of state. Some, actually one of our board members last week had one butchered in his pasture. So they went out, killed the animal, took a 700-pound calf, put it down there and field dressed it like they would a deer and just took all the meat. So there's a wide range of things, whether the implements are stolen and sold again. Same way with the animals can be taken to another livestock market and sold at auction. So depending on how it is, they're
Not recovered usually.
Yeah, usually not recovered.
Interesting. Okay, thank you. Okay, committee, what questions do we have for this group of proponents? Representative Vaughn.
Thank you, Madam Chair. My question is for Mr. Sieber.
Representative.
Hi. So I'm just wondering, for the amendment that you're proposing, I was wondering, are you wanting the theft of grain to also be a level 5 non-person felony? I'm mostly just wondering because I typically think of the market value of grain being a little different than cattle or husbandry implements, and that may be my ignorance.
Yes,
but-
we would like it identical to what else is in the bill. A little story. One of our members out in Western Kansas, and I'm not going to mention the name of the company, had $250,000 worth of grain stolen from him. The person was caught. He was prosecuted. He was given probation and was asked to pay back the company, and that was it. We've had other grain thefts for similar amounts in the middle part of the state. Just recently, another one just right outside of Wichita. This is a real deal, and it's difficult to have it for a company, a co-op or a grain company to take a $250,000 hit. I mean, it's big money.
Thank you.
Representative Carmichael.
Thank you, Madam Chair. Two questions, if I might. First, I think Mr. Pinniger might be best. I would have asked my sheriff this question, but Mr. Pinniger is the true expert in this field, as I understand it. Mr. Pinniger, in preparation for this hearing, I visited with some folks who are proponents of the bill who told me one of the purposes here is to get law enforcement to take these crimes seriously, investigate them, arrest people, and prosecute them. If we raise the penalty for this crime, will you work harder and make better cases and file more cases, or are you already doing it irrespective of what the penalty is?
Well, I don't think my partner and I could work any harder.
I don't doubt that.
There's two of us for the state. We also cross state lines if we need to pursue a case, a suspect, or try to make a recovery. One of the problems we do have is getting the local prosecutors to actually take an interest in our work. It's a lot easier for a local prosecutor to say, well, this is going to be a civil matter. And we've actually had to debate these cases in private chambers with county attorneys to get them to take a look at it. So if they say it's a civil matter, it just goes away, it's off their radar.
I find that difficult to believe, but thank you, sir. My second question is to whomever from the proponents want to answer this. I represent an urban district, and we've got chickens in the backyard. We got burglaries going on all the time. Pharmacist was broken into just a few days ago in my district. We've only got so many spaces at the state penitentiary. Why should I put people in jail longer for farm thefts, agriculture-related thefts, than the people who burglarized 10 houses in my district or the people who broke into the pharmacy just the other day? Why special treatment for the farmer?
Representative Steele.
Madam Chair and committee members, a criminal is a criminal. And in order to assist in hoping to deter criminal activity amongst livestock, having higher, stricter penalties will hopefully deter that.
I wish we could go longer.
Just out of curiosity, what types of of people are committing these thefts? Are they other farmers, or is there a certain type of person that's doing this, or?
So believe it or not, there's always a house mouse involved. So that means there's someone that's familiar with your area, where you live. They know when you go to church, when you go to the copy at the co-op. So they're aware of when you are there and when you're not there. A lot of the times, they'll be the person you least likely suspect that'll do this. So we're seeing a lot of the livestock stolen in Kansas actually go across state lines, and they're sold in markets in Oklahoma and Texas. So does that answer your question, or would you like me to expound on something else?
No, I was just kind of curious if they were other farmers who were.
We have a lot of ag producers because of the high inputs and the high cattle prices. So that's what I mean by house mouse. There's somebody there that knows. But we're also seeing a lot of people with meth habits, and a lot of husband, wife, girlfriend, boyfriend teams that will do this, and they'll steal cattle, and because they can get full face value for those at a market the next morning instead of stripping wire or copper pipes. So to do that, they won't have the equipment. They'll actually steal a pickup and trailer to haul the animals.
All right. Thank you.
Yes, ma'am. Anybody else?
Yep, committee, any other questions? Representative Schreiber and then Barth.
Thank you, Madam Chair. I was just looking at our fine laminated card. I don't quite understand. I see the severity level of 5, but then it's got non-person felony 3 columns there, and then those numbers. I'm not sure what the hell
So that
that
would
means.
be a first.
Oh, first offense?
Second, if you have more than 3 non-person felonies, that's,
And those are months of sentence?
yes.
And
In the corners are the months.
And one question, and I don't know, I say this a little bit in jest, but because there have been news reports about it, are eggs considered under this?
It would take a lot of eggs.
It would, yeah, I understand. But some of those thefts that I've heard about, I mean, it's pretty amazing. But anyway, all right, thank you.
Representative Barth.
Thank you, Madam Chair. My question might be best for you as well. It actually just goes to a second level question, because I am more curious about who is committing these crimes typically. And I just am not as familiar with your house mouse terminology. So if you could be a little bit more like direct, that would be fantastic. Thanks.
Okay, sure. So a house mouse would be, you and I are neighbors. And I know when you go to church. I know when you go with your family to a school event. And I know your vehicles, you know mine. So if you saw me in your pasture or near your pasture, your corral, you probably wouldn't think anything about it. So that would give me the opportunity to take your animals and pretty much undetected. And we do see a lot of that across the state.
All right, just a quick follow-up. So typically it's just your neighbor doing this. Like, we're not looking at outside state, outside states coming in, criminals from outside the country or anything like that. It's mostly within our own state are the criminals.
We do, I would say over half of our crimes are from people out of state. Working a case right now that's just under $2 million, just under 2,000 head of cattle, and he's from Tennessee. So we do see a lot of people come in from out of state because there's no penalty in Kansas. Yes, ma'am. Anything else?
Yep, committee, Representative Goddard.
Thank you, Madam Chair. In the old days, branding was about the only way you could identify a cow or a calf or whatever. But I know there are lots of different ways of doing it today. You see them with the ear tags in. You probably have the inked stuff on the inside of the lip, etc. But have there been many people who have been caught selling stolen cattle at an auction because of the identification that might be on or in that animal?
Kansas is not a brand state. So there are only 6 brand inspected sale barns in this state. So if I'm going to steal your cattle, I'm not going to take them to Hamilton County where there's 2 brand inspectors. I'll sell them at a sale barn where there's no one around. So the tattoos inside the lip, that's mainly for horses, and that's for registered stock. You can't put an EID tag in a cow. It's just not economically feasible to do that. So most of the cattle we see stolen do not carry a brand.
Represent.
Thank you, Madam Chair.
Oh, go ahead. Did you have another question? No. Okay, okay. I kind of interrupted you. I'm sorry. Representative Williams, then Martinez.
Thank you, Madam Chair. I don't know exactly who this question would be good for, but it's a little bit going off of where Representative Carmichael is going on just the value of the livestock. I see that livestock is defined in here and it's included in a level 5 non-personal felony, but is there a level of or a financial number put on that livestock, or is it say I have hobby chickens and they make eggs for my family and that's, you know, our source of food. Does that include that livestock in here?
Cattle are sold at market price. For example,
Could you introduce yourself?
oh, I'm
please?
sorry.
Yep.
Kevin Schwertfeger, Representative, 114th District. And cattle sell at market price. You'll find most recently baby calves that might be sold at the cattle sale at auction will sell for $600 a piece to $700 a piece. And it's not that hard if a person wanted to go grab a baby calf and it might just disappear and you thought maybe a coyote got it, but it.
Okay, and I would like to ask that question also to the revisor. If there are limits, you know, dollar limits on the different penalties in the bill. Is that kind of what you're asking too? Okay, yep. Thank you, Jason.
Madam Chair, Jason Thompson, Revisor's Office. No, and as I was trying to mention in the bill brief, right, the current penalties are all based on value, but the proposal, at least in this, I don't know about a further amendment, but the proposal here is to make it a flat level 5, regardless of value.
Representative Williams.
Thank you, Madam Chair. And this is out of my ignorance. I know crop has insurance and there's a value there. When it comes to livestock, is there insurance on that? And is there a way when it comes to that value being assessed then too for the crime?
Very seldom do you find our farmers buying livestock insurance. It's just not a common practice. Can it be done? I suppose, yes, it could, but the premiums would probably be astronomical with the rise in the price of cattle. Larger cattle, for reference purposes, if you have 1,000-pound steer, they're bringing about $2,500 a piece now for one. So it doesn't take very long, and you have lost quite a bit. And one afternoon, you can lose everything that you had for a whole year. And the stories from, we were just told you get slapped on the wrist. Oh, I get probation. That's a pretty good money-making opportunity if you want to get into this.
Thank you. Thanks. Go ahead and introduce yourself, please, when you come up.
Matt Steele, Kansas Cattlemen's. So the other
Is your-
part of that.
Is your microphone?
Oh, there we go. Sorry, bring it down. Kevin Stiller. The other issue is if you steal that 100-pound calf, that's what the value is today. But that calf is going to be in there for another year, 2 years. But it also might be part of breeding stock, which then makes it $100,000, $200,000. But if you're assessing it only going, it's a $200 calf that we just got birthed out in the pasture. There's no follow through on that. And on the insurance, typically with insurance, the insurance that is used in the livestock industry is they're buying insurance based on the cost. So you're buying an insurance today that my market value when it's ready for market in 8 months, it's going to be plus or minus this many dollars. And you're paying for that insurance to cover that difference versus I'm paying insurance for what that is worth today and holding it on. But you're talking about animals that can take anywhere from 16, 18, 24 months before they're at market value
Sure.
with
And I
regard to that.
recognize there's probably a cost there too with feed. And, I was just curious, Madam Chair, asking, just trying to see on a value wise, as we're looking at livestock, is, stealing somebody's chickens there and that as a hobby from their backyard, the same severity as someone stealing a herd of cattle or several head of cattle. So that's just kind of where I was going with my line of questioning. Thank you, Madam Chair.
Representative Bohai.
Thank you, Madam Chair. To Mr. Steele, or Dr. Steele, but the man. Could you explain a little bit more about breeding stock and some of the costs that could be, why some of those cows might be worth significantly more? And just expound on that just a little bit?
So you could have, okay, so one of the oddest thefts that I remember last year was there was a couple 8-year-olds that were stole out in Greeley County. It's like, who's going to do that? That'd terrible. I mean, obviously it was somebody that didn't know what they were getting. They were going to go try and sell them off or butcher them real quick and get some meat. But you take that one cow that you're going to take off, so then it's calf to heifer to cow, and you go through all this process. Well, it could still birth another 8 or 9 times and then have produced calves from each of that. So you've got a continuous stock, as well as then you have a bull that could last for a certain amount of time that's going to have that many prodigies. So you have some that are solely for breeding stock that are that way, but you also have some that are breeding stock based on solely on genetics. So you do have specific animals, especially now, that are specific where we're crossbreeding in our dairy industry, so that we are breeding dairy animals on the female side, but then we're providing animals on the male side of those progeny that are being set out for the meat industry and being crossbred with specific breeds. So there's a lot that goes into that with regards to different types.
Yes, go ahead.
Sorry. And then are we seeing thefts in the registered cattle, or is it mainly stuff in the field, for lack of a better term?
Well, your stuff in the field's can be registered as well. So there's no, I mean,
I'm talking about like the $300,000, $400,000 cows that we see over at the National Livestock sale type of thing. Like, are those being stolen as well, or are they focusing on smaller farms?
you could have one of those stolen. It would be in Jim. We probably haven't had one here in our state, just because typically if you've got one of those fancy steers, it's going to be up next to the house, just like you're going to keep your pet dog. Those are kind of a specialty item in livestock versus, but you're still going to have a $100,000 bull that's still going to be out on pasture. So you can still have those animals out with the rest of the everyday.
And do you know offhand if chickens are considered livestock?
In this, I believe they, oh, right there. So livestock, cattle, swine, sheep, goats, horses, mules, domesticated deer, and all creatures of the rattatite family.
Okay, thank you.
And ostrich, but not limited to ostriches, emus. So yes, I guess chickens would not be in this, so.
Okay, thank you. Okay, thank you. Representative Barth.
Thank you, Madam Chair. I think we just haven't covered this yet. I find this all really interesting, but how are you typically catching these folks? And how often are you able? How often, that would probably be KBI, I think. How often do you not find who's doing this? Is it at the cattle barn, the sale barn? How are you able to catch these? Is it tip-offs from neighbors, or how are you finding them? Just to give us a little better idea of the process. Thanks.
One of the best tools we have is a mad girlfriend or boyfriend or husband or wife. Seriously. We get a lot of calls from truck drivers that haul cattle that don't get paid for them. They may be owed tens of thousands of dollars for hauling cattle. They don't get paid. And they say, well, by the way, John Doe from Tennessee has been shipping cattle 18 feed yards from Texas to Nebraska, and these are some of those cattle we've hauled, and he never paid for those. So if stolen cattle are sold at a sale barn, we do not recover those and give those back to the victim, because if This gentleman might have bought those, he bought those in good faith. So he wouldn't know they were stolen when he purchased those. So that's why we depend on the court system to try to help us get a conviction and then a restitution that has some teeth in it. Does that answer your question?
Okay, committee. I did not, I'm so sorry. Representative Martinez, you were on the list.
That's right. Thank you, Madam Chair. I'm an avid animal lover, so I have to ask this question. And I know that most times these thefts are for profit, but is there ever any instances when you find these livestock or whatever the case might be where there's animal abuse? There has been animal abuse? No?
No.
Okay, good.
Representative Carmichael, did you have a question while I'm here?
Are you, yeah, is your light, is that light on right there?
Yes, ma'am.
Okay, so just kind of make sure you're speaking.
My question is not for Mr. Pinniger. Thank you.
Okay, so did you get your question answered? Okay.
Kevin Schwartfigger, 114th District, to speak on the subject of animal cruelty. Yes, my father's cattle were butchered. So if that's cruelty, and they took the meat, so.
Yep, thank you.
You mean
Okay,
out of
go
the
ahead.
normal process of butchering?
Yes, they were young in their life, and usually they go quite a ways longer and live a longer life.
And they probably weren't stunned, the way they do in a.
Right.
I mean, the
There's a
stunning.
certain way to do it, and I don't know that was done properly.
Okay, yeah.
Thank you.
Representative Carmichael.
Thank you, Madam Chair. This has indeed been an interesting and informative discussion. I appreciate everyone taking the time to be here. I think we just established that maybe chickens aren't covered under this bill, but goats are, I assume. So my question to the reviser is, under this new statutory scheme, would the theft of a $100 goat merit the same penalty as the theft of a $2,500 cow? Is the value of the property relevant to the punishment imposed under this bill?
Jason.
Madam Chair, to answer your first question, yes, the same penalty for each of those cases. And second question, no, value doesn't matter.
And so the immediate follow-up is, I assume the same is true with implements of husbandry, that the 75-year-old plow that I had on my losing farm, it sounds like it's the same penalty as if it's a $750,000 combine. Is that right or not? $1 million combine, $1.5 million. An Alice versus a John Deere, I don't know.
Yep. So Jason, I'm sorry, I don't think we heard you.
Madam Chair, correct. Value does not matter.
Thank you.
Okay, committee, any other questions? This has been an interesting discussion. I will call your attention to written only proponents. I won't read them all. We have several sheriffs and folks from different associations, so please do take a look at that. Okay, as long as there's no other questions, any other testimony? Representative, would you like to make a closing remark? Is it, yeah.
Kevin Schwartfigger, 114th Rep. There are values established within the bill in husbandry, in equipment and levels.
Okay, in the equipment section.
Just
Well,
to clarify that.
To make sure that the reviser's wrong and the representative is right.
Thank you.
okay, thank you for that information. Do we have okay, not seeing it at this point, but we can talk more about it as okay, that sounds great. Okay, Jason, if you, okay, we're not going to take the time at the moment to figure that out exactly, but we will get more information from the stakeholders and from the revisor and be able to, before we work this bill. Yes. You may talk to each other. Yeah, you're right, exactly. Okay, without any more questions, I will close the hearing on House Bill 2253. Okay, committee, I will let you know that the plan is that we are going to work tomorrow. I do owe you treats. My phone went off, so we will have some good treats. It's Valentine's Day, so we'll do something good. If you want to take down this information, first of all, we will have a hearing on House Bill 2347. It has to do with auto theft. So we are going to have a hearing on that bill. I don't think it will be a lengthy hearing. What? Oh, I know. And I didn't use that simple word, so. Okay, but we will plan on working as long as we get amendments and all the parties come together and we have kumbaya, but I don't know about that. I would like to work 2134, which is the open records charges, 2371, which is the LLC bill, 2359, which is the guardianship bill that we just heard. HCR 5008, which is the resolution on the rules and regulations. And 2323, which was the bill that we heard today from the insurance department. I will let you know that I think we're going to have an opportunity to have some bills after turnaround. It's not official, but probably tomorrow, the speaker will bless a few of our bills. The scrap metal bill, the jailhouse witness bill, and the tenure bill is what we're asking for, so that we can give those 3 bills more time for us to work them rather than work them. I don't think I've left anything out. I think we will have to work on Monday. It won't be a long hearing or long meeting, but I think we will have to work on Monday. So do plan on that, and I'll let you know more about that tomorrow. Okay, any questions, committee? Yes, we would love to meet earlier. Unfortunately, our revisor does have corrections tomorrow, and the chair of corrections is in here too. That's at 1:30. So we aren't able to meet any earlier since Jason is quite a mandatory figure in the committee. Yes. Okay, anything else for the good of the committee? We're adjourned. Thank you, everybody.